Hello, good day. Here, doing another reading today, and today our reading is of it's a document. It's like a legal document. It's a bill, actually. So we're reading a bill, one of those government bills, sitting on Capitol Hill, and yeah. So I'm interested in how I'm going to end up editing this video, because this is just like a long legal document. It's long in quotes, I guess. It's only like 8 pages or so. Yeah, it's just the bill. As far as the current, more recent times, okay. So as of the releasing of this video, this is current to whatever media, all that stuff. I won't delve too deep into that. Yeah, but like I heard stuff about it. Heard some people weren't really a fan of it. Some people don't have a problem with it. I don't know. I'm just here to read. That is all. Uh, So yeah, I'll get into it, and also it's like all like numbered too. Like every line has a number. It's like all no, it's weird seeing legal documents like this. But yeah, I'll get into the reading. And it says that stricken language would be deleted from an underlying language would be added to present law. I have no fucking clue what that means. No fucking clue. Is this some kind of key to read bills or something? I have no clue. No clue what that means. Okay, it says State of Arkansas 93rd General Assembly, regular session 2021. As engrossed H3 921. I don't know what that means. I don't know, what is that? 9th of March, maybe? I don't know. It says a bill. Is this how we pass bills? We just call them a bill. Okay, Senate Bill 289. By Senators K. Hemmer, Beckham, Bledsoe, Flippo, T. Garner, Gilmore, Hester, Irvin, B. Johnson, M. Johnson, Rappert, G. Stubblefield, D. Sullivan, by Representatives B. Smith, Beck, Bentley, Baru, maybe Brox, no, that's Baru, that sounds French. The next would be silent. Brown, Cloud, Gazaway, Ladyman, Lowry, Lundstrom, McCollum, Peyton, Penzo, Richmond, Rye, maybe it's Ray. I'm just gonna say Rye, Speaks, and Womack. And I will say those names sound absolutely ridiculous and sound just like a politician name. Like almost very like B. Smith was the most normal name up there. Yeah, like Johnson, Smith, um, Brown, Richmond. No, like a lot of these names, like those names sound normal. Like some of these, like fucking Flippo, like Flippo. It's Spanish for flip. I don't know. I'll try not to hang on this, but like it just sounds like some weird names. Okay. For an act to be entitled, an act to create the Medical Ethics and Diversity Act, and for other purposes. Subtitle to create the Medical Ethics and Diversity Act. We're on line 20 now. Be it enacted by the General Assembly of the State of Arkansas. Section 1, Arkansas Code, Titled 17, Chapter 80, is amended to add an additional subchapter to read as follows. Subchapter 5, Medical Ethics and Diversity Act. 17-80-501 title. This subchapter shall be known and may be cited as the Medical Ethics and Diversity Act. 17-80-502 Legislative Findings and Purpose. A. The General Assembly finds that 1. The right of conscience is a fundamental and unalienable right. 2. The right of conscience was central to the founding of the United States, has been deeply rooted in the history and tradition of the United States for centuries, and has been central to the practice of medicine through the Hippocratic Oath for millennia. 3. Despite its importance, threats to the right of conscience of medical practitioners, healthcare institutions, and healthcare payers have become increasingly more common and severe in recent years. 4. The swift pace of scientific advancement and the expansion of medical capabilities, along with the notion that medical practitioners, healthcare institutions, and healthcare payers are mere public utilities, promise only to exacerbate the current crisis unless something is done to restore the importance of the right of conscience. And it is the public policy of the state to protect the right of conscience of medical practitioners, healthcare institutions, and healthcare payers. B, so that's the end of so all those numbers were of A, so this is B of the legislative findings and purpose. It is the purpose of this subchapter to protect all medical practitioners, healthcare institutions, and healthcare payers from discrimination, punishment, or retaliation as a result of any instance of conscientious medical objection. 17-80-503 Definitions. As used in this subchapter, 1a, conscience means the religious, moral, or ethical beliefs or principles of a medical practitioner, healthcare institution, or healthcare payer. B. Conscience of an institutional entity or corporate body may be determined by reference to existing or proposed documents, including without limitation any published religion, moral, or ethical guidelines or directives, mission statements, constitutions, bylaws, articles of incorporation, policies, regulations, or other relevant documents. 2a. Discriminate means to take an adverse action against or communicate a threat of adverse action to any medical practitioner, healthcare institution, or healthcare payer as a result of a decision by a medical practitioner, healthcare institution, or healthcare payer to decline to participate in a healthcare service on the basis of the conscience of the medical practitioner, healthcare institution, or healthcare payer, including without limitation 1. Termination. 2. Refusal of staff privileges. 3. Refusal of board certification. 4. Adverse administrative or disciplinary action. 5. Demotion. 6. Loss of career specialty. 7. Reduction of wages, benefits, or privileges. 7. Refusal to award any grant or contract or other program. 8. Right? Sorry, it's all in Roman. I'm trying to. It's 3, 4, 5, 6, 7, 8. Okay, no, this is 9. Okay, I must have repeated a number. 9. Refusal to provide residency training or opportunities. 10. Refusal to authorize the creation, expansion, improvement, acquisition, affiliation, or merger of a healthcare institution. 11. Reassignment to a different shift or job title. 12. Addition or increase of administrative duties. 13. Denial, deprivation, or disqualification of licensure. 14. Disqualification from or without holding of financial aid or other financial assistance. And 15. Any other penalty or disciplinary retaliatory action, whether executed or threatened. Okay, now B, so all that was 2A, now we're going to what I assume is 2B. Discrimination does not include the negotiation or purchase of insurance by a non-government entity. Okay, it's the end of 2B, I was going really short. Now we're going to 3. Healthcare institution means a public or private organization, corporation, partnership, sole proprietorship, association, agency, network, joint venture, or other entity involved in providing healthcare services, including without limitation, A hospital, B, a clinic, C, a medical center, D, an ambulatory surgical center. Ambulatory surgical center? I don't know what those are. E, a private physician's office, F, a pharmacy, G, a nursing home, H, a medical training facility, I, an individual, association, corporation, or other entity attempting to establish a new healthcare institution or operating an existing healthcare institution, and J, any other institution or location where healthcare services are provided to an individual. Okay, that's the end of that list. Now we're going to number 4. So that was 3, and that was listing all those letters. Now we're going to 4. And remember, this is all numbering definitions. Yes. Healthcare payer means an employer, healthcare plan, health. Let me restart the sentence, please. Healthcare payer means an employer, healthcare plan, health organization. No, I skipped a whole line there. Health maintenance organization, insurance company, management services organization, or any other entity that pays for or arranges for the payment of any healthcare service provided to a patient, whether the payment is made in whole or in part. All right, number 5. Healthcare service means medical care provided to a patient at any time over the entire course of treatment, including without limitation, A, initial examination, B, patient referral, C, counseling or psychological therapy, D, therapy, E, testing, F, research, G, diagnosis or prognosis, H, instruction, I, dispensing or administering or both of any drug, medication, or device, J, setup performance of a surgery or other procedure, K, record keeping and record making procedures and notes related to treatment, and L, other care or services provided by a medical practitioner or healthcare institution. Alright, so that was 5. Number 6, medical practitioner means an individual who is A, a physician, B, a physician assistant, C, an advanced practice registered nurse or other nurse practitioner, D, a pharmacist, E, a medical researcher or laboratory technician to the extent that he or she is requested to actively and materially participate in medical research or testing that violates his or her conscience. F, a counselor, social worker, psychologist, or other mental health care professional to the extent that he or she is requested to actively and materially provide or participate in a type of counseling or referral for a health care service that violates his or her conscience. G, a student of counseling, psychology, social work, or other mental health studies to the extent that he or she is asked to actively and materially participate in a type of counseling or referral for a healthcare service that violates his or her conscience. Or H, a nurse, pharmacy technician, surgical technician, allied health professional, student, faculty member, contractor, or employee who is requested to actively and materially participate in a surgery, procedure, and medication administration or dispensing that violates his or her own conscience. And 7, okay. Yeah, so number 7, so I was all listing out number 6, which was a medical practitioner. So number 7 is defining the word participate. Participate means to provide, perform, assist with, facilitate, refer for, counsel for, advise with regard to, admit for the purposes of providing, or take part in any way in providing any healthcare service or any form of healthcare service. Alright. Alright, looks like the definition thing might be over. Yes, it would be from the context clues I pick up. Because now it says 17-80-504, right of conscience. Maybe it is still defining these words. I don't know. This is damn government shit. Right of conscience. A. So this is subsection A of that. A medical practitioner, healthcare institution, or healthcare payer, 1, has the right not to participate in a healthcare service that violates his, her, or its conscience. 2, is not required to participate in a healthcare service that violates his, her, or its conscience. Is not civilly, criminally, or administratively liable for declining to participate in a healthcare service that violates his, her, or its conscience. 4. Is not civilly, criminally, or administratively liable for the exercise of conscience rights not to participate in a healthcare service by a medical practitioner employed, contracted, or granted admitting privileges by a healthcare institution. And 5. Shall not be discriminated against in any manner based upon his, her, or its decline to participate in a healthcare service that violates his, her, or its conscience. Alright, so section B, exercise of the right of conscience is limited to conscience-based objections to a particular healthcare service. C, a medical practitioner, healthcare institution, or healthcare payer that holds himself, herself, or itself out to the public as a religious payer that holds himself, herself, or itself out to the public as religious, states in its governing documents that it has a religious purpose or mission and has internal operating policies or procedures that implement its religious beliefs, has the right to make employment, staffing, contracting, and admitting privilege decisions consistent with his, her, or its religious beliefs. D. So for that last part there, so it looks like they have, hold on. South, yeah, so it's got like, just because I feel like people who may be reading may be interested in what I just said, or like what that means. It looks like if a like medical practitioner, healthcare institution, or healthcare payer, if they hold themselves as religious to the public, and they even have like government documents saying that they, their purpose is to be, act in that religious manner or moral whatever, then it's good. But it sounds like if they don't, then you can't really do that. So you're gonna have to like probably go out of your way. I'd imagine you probably have to like do stuff to get to the place where be able to do anything. That's just what that part seems to me. I don't know, there's something I could use to damn edit. I guess I could show that maybe. I'm not sure. I don't know how I'm gonna edit this. This is gonna be weird. Alright, so section D. The right of conscience described in subsection A of this section does not include the right to deny emergency medical care as required under 42 USC. What the hell is that symbol? Oh my goodness, is this like what? Hold on. Search the web for that. Hold on, I got a section sign? The section sign is a typographical character for referring individually numbered sections of a document and is frequently used in signing sections of a legal code. It's also known as a section symbol, section mark, double S, or silk. Okay. There we go. I'll have that in the video. I show you what the symbol is. It's weird. It's like a double S and they're all on top of each other. It's all weird. Looks like some wizard stuff. I don't know, Lord of the Rings kind of thing. It's like J.R. Tolkien just did a little signature or something. I don't know. So 130. Okay, what the? Okay, 1,395 or 1395 DD. I don't know. Was that a bra size? As existing on January 1st, 2021, or any other federal law governing emergency medical treatment as existing on January 1st, 2021. So what the hell did that even say? This right of conscience is section does not include the right to deny. Okay, the right of okay. Let me just repeat that whole paragraph or sentence technically. It just says multiple lines. Okay, D. The right of conscience is described in this subsection. A of this section does not include the right to deny emergency medical care as required under whatever the hell that is, as existing on January 1st, 2021, or any other federal law governing emergency medical treatment as existing on January 1st, 2021. E1. When a medical practitioner declines to participate in a healthcare service for reasons of conscience, the medical practitioner shall alert the employing healthcare institution at the earliest reasonable time and comply with any applicable protocol developed under this section. 2A. A healthcare institution may develop a protocol for situations in which a medical practitioner declines to participate in a healthcare service. 2B. The protocol shall provide for prompt patient access to medical records to facilitate transfer if needed. 3. This section does not require a healthcare institution or medical practitioner to perform a healthcare service, counsel, or refer a patient regarding a healthcare service that is contrary to the conscience of the medical practitioner or healthcare institution. F1. This section does not prohibit any employer or contracting healthcare institution from disclosing the specific healthcare service that an applicant would be required to participate in if he or she is hired for the position or contract. I don't know what that means. I don't think that added any helpful information. What the hell? This section does not prohibit any employer or contracting healthcare institution from disclosing the specific healthcare service that an applicant would be required to participate in if he or she is hired for. What does that even mean? They just I don't know. I think they just like what? You guys like what? What is? I thought I knew what the word disclosing mean. Maybe I don't. Because it sounds like they're saying we don't prohibit employers or healthcare institutions from telling their employees that the healthcare services. What? I don't know. What is it? I don't know. Who wrote this bill? Who wrote it? Oh my goodness. Do you need like a master's degree or a PhD to read? Is this has to be an English major. And if they wasted their time. Oh my goodness. You imagine going to school to learn a language you already knew just so that no one else could read what you're writing. God. What does this say? Oh, this is why I didn't make it like a 36 on the ACT. I don't know. What the? Healthcare institution from disclosing the specific healthcare services that an applicant will be required to. What? Okay, maybe it says it F2. So that was F1. F2. Upon being informed of the specific healthcare services required of the position or contract, the applicant shall disclose whether he, she, or it has conscience objection to any of those required duties. 3. However, a medical practitioner or healthcare institution shall be able to decline to participate in a healthcare service that violates his, her, or its conscience if the employer or contracting healthcare institution, after employment, adds healthcare services to a medical practitioner's or healthcare institution's duties that would require the medical practitioner or healthcare institution to provide services that violate his, her, or its conscience. G1. Okay, so like before I get into the G1, so that last thing made more sense. I have no idea what F1 was about. F2, F3 made like I understood what they were saying. F1, and like I said, we don't like, hey, you employers and contractor people, we don't prohibit you from informing your employee of what the job is required. I don't know. That sounds like really stupid. Imagine having to go your way to say that. Like, was there any vibe saying employers aren't allowed to tell you what your job is? Like, that just seems like unrealistic. I don't know. Like, imagine, and who would want to go like get a job somewhere where the employer wasn't telling them what they're doing? I don't know. I don't know. It just seems weird you have to go out of your way to say that. I don't know. maybe I'm not a lawyer person, so maybe there was some weird business beforehand that I read that I didn't understand, saying mixed signals. I don't know. This is just weird. This sounds like communism. Anyways, so am I on? Oh yeah, G1. Let me scroll down this thing real quick. Okay. A healthcare payer shall file its conscience policies annually with the state insurance department by including a comprehensive list by billing code of any and all products, services, and procedures that the healthcare payer shall not pay or make payment for reasons of conscience. Alright? I want to read that again because I do not remember reading that. So, sorry, bear with me, people. I'm going to read it one more time. G1. A healthcare payer shall file its conscience policies annually with the state insurance department by including a comprehensive list by billing code of any and all products, services, and procedures. The healthcare payer shall not pay or make payment for reasons of conscience. Okay. So yeah, okay. If you want your stuff, you want to be able not to do a thing, you have to go make some papers and write them down beforehand, and you gotta update it every year if you want to add something new. Or no, you just have to do it annually, regardless. You have to keep doing it, or it's gonna be assumed you don't. Okay. 2. The annual filing described in subdivision G1 of this section shall A. be provided annually to each beneficiary of the healthcare payer and on the website of the healthcare payer, and B. not be required for any year in which the healthcare payer will not exercise its conscience rights under this subchapter. Not be required for any year in which healthcare payer will not. Okay, what? Not be required for any year in which the healthcare payer will not exercise its conscience rights. So you just kind of like go back and off. Like it's not required for like a year you don't care, but next year you may want to go back to caring again. That's interesting. Is there like any like moral system that works like, hey, like when it's a leap day or on holiday, I don't know, on the year of the cow, yeah, it's all all dice roll out or something. I don't know. Be interested. So yeah, H. No, not H. Yes, H. No, H. No, I read H. I'm on I. Excuse me. A healthcare payer shall not compel by undue influence, fraud, or duress? Duress? Or duress? Hold on. We're gonna look up duress. Because duress does not sound like a word to me. Duress. Threats, violence, constraints, or other action brought to bear on someone to do something against their will or better judgment. So in law it says constraint illegally exercised to force someone to perform an act. Yes. So a healthcare payer should not compel by undue influence, fraud, or duress a healthcare provider, healthcare institution, or beneficiary to accept a contract or contract amendment that violates the conscience of the healthcare provider, healthcare institution, or beneficiary. J. The department may issue rules and take any other action necessary or appropriate to enforce subdivisions G through I of this section. Alright, that part looks done. We're on 17-80-505. Civil remedies. A1. A civil action for damages or injunctive relief, or both, may be brought by a medical practitioner, healthcare institution, or healthcare payer for a violation of this subchapter. 2. A2. A claim that the violation of the subchapter was necessary to prevent an additional burden or expense on another medical practitioner, healthcare institution, healthcare payer, or individual, including without limitation a patient, is not an affirmative defense. B. 1A. Upon a finding of violation of the subchapter, the aggrieved party shall be entitled to recover three times, what the hell? Three. Okay, so I'm assuming a legal document, they'll say the word three, they'll type that out, and then have the number three next to it. For people who don't know the difference between like the word and the number, give it to you both. Now, that sounds like a thing, but how come they don't do it for other numbers? I don't know, maybe it's in context and weird law, business, I don't know. It's all weird to me. Anyways, so I'm just gonna read that again and pretend like there's only 1 3. The aggrieved party shall be entitled to recover 3 times the amount of any damages incurred, including, without limitation, damages related to I. The cost of the civil action, and 2. Reasonable attorney's fees. Alright. B. The total amount of damages shall not be less than $5,000 for each violation, in addition to the cost of the civil action and reasonable attorney fees. Now, in that case, that said $5,000 and had the number equivalent to it too. Did the same thing. Okay. 2. Damages shall be cumulative. Oh hell. Cumulative. Ah, fuck. Damages shall be cumulative and are not exclusive of other remedies that may be afforded under state or federal law. C. A court may award injunctive relief. Sorry, my mouse is in the way. Yeah. A court may award injunctive relief, including without limitation, ordering the ordering the reinstatement, okay, one of those words, of a medical practitioner to his or her prior employment position, or board certification or relicensure of a healthcare institution or healthcare payer. 17-80-506 Applicability. This subchapter is supplemental to existing protections of the right of conscience within the Arkansas Code and does not affect the existing laws within the state concerning protection of the right of conscience. S.K. Hammer. Okay, so S.K. Hammer, you write this? You're the one who wrote that nasty sentence? Where is that nasty sentence? Where is that? What is that? G.I.? Where is it? Or F.I.? That's how. Yeah, you wrote F1, Mr. S.K. Hammer? I don't know. I am very curious, Mr. S.K. Hammer. Or Miss, I don't know the gender. Or it, whatever. All the pronouns, okay. What is F1 for 17-80-504 section 3F1, where it says this section does not prohibit any employer or contracting healthcare institution from disclosing the specific healthcare services that an applicant would be required to participate in if he or she is hired for the position of contract. Was this necessary? I doubt you ever watch this video, but in case you do, or if anyone who might understand, who isn't just like, I don't know, I would like for this to be explained to me. This seems like, I don't know, it'd be like if Walmart had like a sign on the door saying, "We don't prohibit you from walking in the door and shopping at our store." I don't know, like, oh really? Had no idea. Like, I don't know, it just seems, I don't know, I'm not trying to get beat up over this, but why? Why was this? This seems like redundant. It looks like filler. When you're a part of like district senate or whatever it's called, or is it like English class in school? Do you have to meet a quota and you just like wrote, filler, like fluff? Is that why everything's like double spaced or something? You have to like meet a word count, but actually though, is this thing? I wouldn't imagine. I feel like you could probably like write a bill that's like like a line long or something. I feel like that'd just be an amendment at that point, not a bill. Um, yeah. No, it just seems. No, it just seems like filler. No, this is something like I'd like a friend of mine would write if they were writing an essay for their comp class. Like there's like I don't know. I have a friend of mine who not that good with their writing skills, and they yeah, this just seems like something they would do. Uh, I'll never let that person down for a certain essay they wrote in AP Lang because it was so ridiculous. Oh, ridiculous. Oh, don't get me started. He had a horrible Trail of Tears essay. Oh, horrible. The Trail of Tears, period. Oh, no, this isn't that bad, but it's just like, oh, it seems so redundant. Anyways, let me not, bark up that tree the whole day. Yes, that's March 9th, 2021. On 11:54:54. Cool numbers. JMB006. Alright, so that's that bill. That was the Medical Ethics and Diversity Act. So this is act or a bill? I don't know. Are acts bills? Are these? I'm not sure. I don't know government stuff. Don't know legal stuff anyways. And I still don't know what stricken language would be deleted from, and underlined language would be added to present. I don't know what stricken language. What is like the other words, like the titles and the things, and the underlined language would be added. Oh, I think I get it. So everything with underlined. All right. I'll try like show you a picture or something. I don't know. I'll try to edit something. It's like this is going to be the law now. Anything that is stricken on the paper is not going to be on law and will be deleted when you put it in the law. This is just the bill telling you this will be the law. Oh, I get it. Look at that. See, once you have the power of reading, you can understand this stuff. Amazing. Look at that. All right. So yeah, so that was that bill. Hope you had a nice. Oh my goodness, has it been this long? Oh, I'm so sorry. Oh my goodness. I bet that could have been way shorter. Probably spent like. No, my bad, my bad. That was way longer than I intended. This was like 8 pages and no idea it was gonna be this long. Thought it'd be like maybe 20 minutes. Oh man, twice as long. Alright, I apologize for that. But yeah, okay, well. Hope all of y'all have a good day.